place. Second of all,
Yeah.
I know, but I want to read as relates to military service. I've got a military service.
And would you like also, we've got AMC provisions, we also,
Yes.
the state provisions.
I spent years with the Guard, and I want to make sure we're absolutely taking care of Guard personnel for service to this country.
Okay, I'll put together a package for you.
The other thing is, we talked about this as being baseball negotiations. Have you ever been involved in labor negotiations in your life? Or is this an esoteric discussion because you claim you're the drafter of this? I just want to make sure you've actually been across the table in labor negotiations, and it's not just what you viewed it without being involved in it.
Well, Mr. Trainee, if I might, that's one of the reasons why we reached out to Mr. Owens.
So is the answer yes or no?
And the answer is, while Will has some participation in negotiations, we also work with people who have even more experience in it.
But I'm asking Will specifically, because we don't have a contractor relationship now with those other attorneys. I want to know if this attorney has actually got the experience to be on the line with something like this.
Well, what's going to happen, Mr. Trainee, is on the 18th, we have another attorney that's starting with us, and she has a significant amount of negotiation experience. So we'll be utilizing Mr. Earhart, the attorney that's coming on board next week, and as we get closer to negotiations, we will certainly reach out to outside expertise as well.
I've participated in every negotiation that's occurred over the last 2.5 years to one degree or another. I've also been to MIT and Harvard and trained in negotiations, and I have 18 years of legal negotiation experience, which is a little bit different than labor, and it tends not to always be quite as complicated, but sometimes it's even more complicated.
Okay, thank you. Other questions, I've been looking at hours, watching videos of the Assembly in 2008 contracts when they approved them. And many times I get the impression the Assembly approved contracts they never read. Much like Congress approved laws come to it they never read. And that's my fundamental problem with saying, don't worry about it, trust us, we're going to bring managed competition to you. That worries me because it's the same thing as the Assembly's accused of doing in 2008 and Congress is guilty of doing with things like the health care law, not reading it. Thank you, Mr. Chairman.
Ms. Gray Jackson.
No. Can you hear me?
Yep.
Can you hear me?
Yes, we can.
Great, thanks, Mr. Chairman. I apologize for not being able to be there in person, but I'm in the Seattle airport. Anyway, I'm working from the document that I picked up yesterday, and so the line numbers may be a little bit different. But I'm referring to on my document, page 30, line 14, where it says, shall be subject to the municipal leave policy. My question is, does it mean that you guaranteed the MOA policy, or that you're just limited to that policy? Thank you, Mr. Chairman.
Thank you, Ms. Gray Jackson.
Starts on line 11. Page 30 starts on line 11.
This is referring to the standardization of those extended leave policies. If I have the right section, that let me just go back and confirm that we're all maybe looking at the same section.
Actually talks about all benefits, premiums, deductibles. It's basically all municipal employees shall be subject to.
So it's on page 30 of the document I have, as paragraph beginning with, or line 8 to 12. So this is referring to is the standardization of the benefit programs and leave policies. We're really focused here on the extended leave, and this comes back to what Michelle Frasca, Dennis Frasca had asked about where they would be, and it's having your personnel rules, setting the standards and defining what those programs are, and adopting those as the standard or a uniform policy or program across the entities. And I don't know if Ms. Gray Jackson was able to catch.
Were you able to hear that, Ms. Gray Jackson?
It wasn't really clear, but that's my problem. So.
We'll get it to you in writing, Ms. Gray Jackson.
She said thank you.
Mr. Harneman?
Well, I'll help out, I think, a little bit, because I have the same question. And I suppose it's presupposing that it goes back to 3.30 on the personnel rules, but Are you saying that these are items that will not, like the leave policies and programs are not subject to negotiation?
That would be uniform.
So no matter which bargaining unit you belong to,
Right.
it'll all look the same?
That's right.
And that will be addressed under 3.30?
That's right.
Is currently that?
And let me just step back, that is different, as Will mentioned, because I know that this was another question, that is different than what people may have asked about leave accruals.
Right.
That's not the leave programs we're referring to, leave accrual meaning 6 hours or 8 hours.
Right.
That is not part of this section here.
Okay, so sick leave, leave cash pool.
That's correct.
Leave cash in, these are all the areas you're
That's-
talking about.
I'm talking about your extended leaves. You may have education leaves, you may have family medical leaves, your military leaves, personal leaves, and even the leave donation program as standard programs.
Those will all be in 330. The other leaves, I think that you're talking about, will then be handled now.
That's your negotiation, your leave accruals or your sick leave accruals, that's your negotiation.
So that just brings
That's
up the
your
whole-
contract.
I guess my concern is that, you know, Ms. Johnson earlier said, is it our policy? This isn't policy, this is law. And so I'm concerned that we're moving so fast that we're putting stuff in here that says in law that later puts us behind another limited gun barrel, if you will, by either encouraging employers and supervisors to do something that would be in violation of what the code says. So it just brings another set of questions up there. I think we'll just, I don't know what that'd be. I got another question though, if I can move on, and I guess we'll have to get back to that. I'm
Well,
curious.
what we can do, we were just talking about, is we can give you a chart that tells you which leave topics, if you will, come
So
under
something
330.
like what Ms.
Similar
Kraft
to
could
that,
put.
yeah.
Okay. That'd be helpful, thank you. And then I'm going to, I think it's page 8, no, 9, I'm sorry. Back to page 9 for a minute, and then I'll go to 8. I guess I'm struggling with, again, going back to law versus policy, and going back to collective bargaining. And that goes back to, I have no problem absolutely whatsoever with number 11. I think communicate times of emergencies and declarations and such, I think management has and should have its total right to make sure that we're getting services where they need to. The other concern is, you know, when you have the language that's already in place, and adding the underlying language, which is apparently the insertion, it almost begs or screams out, you know, something to, how it would be best phrased, but in accordance with the collective bargaining agreements. Because again, it goes back to collective bargaining, wages, hours, and working conditions. I mean, if, for instance, I'm going to use the example of 4 versus 3 on a fire truck. If the National Fire Standards comes in and they recommend highly a 4 because of acres safety and public safety, more than just crew safety, but safety to the community, and it's bargained across the table in good faith, and it's in the CBA, then what code says here is if, no offense, but the next mayor decides, no, I want 2. But yet the collective bargaining agreement said 4. Law says that it's management's sole discretion to say who's going to be in the truck or how many's going to be in the truck.
Well,
And that's bargaining.
but, yeah, right, in that example, if it's in the CBA at 4, that's what it is.
But it
4.
doesn't say it. It says in here that you have the right at any time.
No,
management could come-
Not contravention of a signed agreement.
Well, it doesn't say that in here.
That's
I guess
the
that's
law.
me.
That's the law, I mean,
Yeah.
that's exactly how
Signed
it works.
agreement rule trumps.
Yeah.
I guess I would feel more comfortable if it had something in there. Now, maybe it's in the beginning or the end, and maybe I'm missing it.
It's just, that's how the law operates, and I think the problem is, as I said before, management rights and wages, hours, and working conditions
Right.
just really, really overlap.
Right.
And if you say these are absolute, then there is nothing to negotiate.
That's
However, if you were to say they're not absolute, that the contract itself may, even if its language is not there, what the battle is, the tension is when we negotiate something in the contract that says something about safety. How broad is that? And that's where the lawyers get paid, is we fight about how much we've given away in the contract or how much we haven't given away in the contract.
And I have no problem
This has
with-
just strengthened it, that we're going to try to have a little bit more control over equipment. If it specifically says 4 versus 3, that's in the contract, we can't change that. But that doesn't mean we also gave up what kind of tires they have on them.
I give you that. And again, I have no problems with the arguments of lawyers, that's what you get paid to do, and you're supposed to bargain and negotiate hard. I would expect that. I'm concerned that we're putting something in code that overreaches, once again, because as my understanding from law, federal law trumps state law, trumps city law, then you get the signed agreements. And if we're saying FLSA, we go back to the argument and the example of you're locking in at a federal FLSA, what's to say that the state trumps the federal, it doesn't? What's to say the locals, and what does the signed agreement say? If it's not in the code, if it isn't in the law that says we can, then we're being restrictive. And that's
This language that you're talking about in this section does not and would not trump the CBA. Bottom line.
And would there be a problem putting that in,
Well, the existing,
inserting it?
no, because then it would void this whole section.
Well, actually,
I don't believe that it would.
yeah. If you look at B, for example, it speaks to that question, but I will take your concern
I think
and get a response for
I
you.
appreciate that. So going to page 8 then, back on line, section 3H3,